Good morning, ladies and gentlemen. Good morning. I want to thank you in advance for keeping an open mind and paying attention today. We are here today because on October 22nd, 2024, this man, defendant Carlos Fisher, assaulted his wife, Stacy Fisher, by telling her that he would light her ass up, and then he raised his fist as if he were about to get her. I anticipate that complainant Dennis Fisher will testify that this happened at 6112 Swan Lake Road in Romulus, Michigan. At that time, I believe both parties were invited into the house. You will hear, I anticipate that you will also hear from the party's adult child, Miss Carlos Fisher, who was present during the incident. She was present in the home during the incident, but she did not see what happened. I anticipate that she will testify that she heard defendant tell complaining witness, or that she heard defendant tell Ms. Fisher that he would light her ass up. I anticipate that you will hear a recording of a 911 call where Ms. Stacy Fisher calls 911 to tell police that defendant just threatened to light her ass up and assaulted her. And I know Judge already touched on this, I'm not going to belabor it too much, but for an assault...
This case isn't about bruises, broken bones, or physical violence. It's about fear, a split-second gesture, a raised fist, and words that allegedly crossed a line inside a marriage already under strain. The prosecution says this was domestic violence by intimidation. The defense says it was nothing more than an argument blown out of proportion. But when you strip it all down, the real question becomes, where does anger end and criminal assault begin?
In this case, defendant is charged with one count of domestic violence. In order to prove that, I have to show first that defendant assaulted Stacy Fisher. An assault is an attempt to commit a battery or an act that will cause a reasonable person to fear or apprehend an immediate battery. And a battery is a forceful, violent, or offensive touching of a person or something closely related to him or her. So in this case, the assault would be defendant raising his fist as if he was going to punch Ms. Fisher. And I have to show that defendant had the ability to commit a battery, or that Ms. Fisher reasonably believed that he had the ability to commit a battery, so that Ms. Fisher reasonably believed that defendant had the ability to punch her at that time, and that defendant intended to make her fear. The next thing I have to prove is that the parties were married at the time of the offense. I anticipate again that Ms. Fisher is going to testify as being married to the defendant. Like I said earlier, this is a simple case. Testimony is evidence. I anticipate that after you hear testimony from Ms. Stacy Fisher, her daughter, Ms. Carlos Fisher, and you hear the 911 call, the totality of the circumstances will lead you to conclude beyond a reasonable doubt that defendant assaulted Ms. Fisher on October 22nd, 2024 by raising his fist at her as if he was going mad. Thank you.
Mr. Hadley, now.
Yeah. Ladies and gentlemen of the jury, get a task in front of you today. It's pretty straightforward. So as you've all agreed during our jury selections, to keep an open mind and carefully listen to the evidence, listen to what you hear, listen to what you don't hear, listen to what evidence will be missing today that you think would be really helpful if you're trying to make a decision to hit that burden of beyond a reasonable doubt. Now, ladies and gentlemen, as you're kind of digesting what the prosecution just told you today, we are in agreement about one thing. This is a case for domestic violence, and there's been no allegations whatsoever of any actual physical contact. Nobody was pushed, nobody was kicked, nobody was shoved. No one picked anything up and threw it at anyone. There was no physical contact made. What we're talking about today is assault by apprehension. Fancy word of saying, I committed an act and I had the ability to follow through with that act. That act put you in a reasonable fear but I was going to offensively, harmfully touch you. Think back to the playground, the old tooth reflection. You know, you pull your hand back and your buddy actually cowers because you're going to hit him. That is assault by apprehension. Ladies and gentlemen, that's the prosecution's case. That's what they're telling me. Because my client committed an act that a reasonable person, objectively, in what the reasonable person put in that position would have felt was basically putting them in immediate fear of being harmed. Not that what happened hurt their feelings or it was a really lousy thing to say, or that the family was going through a lot, or that the marriage was breaking down. All those things don't matter. The only thing that matters is you really listen to the evidence today. Is you have to make the determination, did the people prove that very, very high burden that there's evidence beyond a reasonable doubt to show that this man's actions put his wife in reasonable fear of being harmed. Now, I want you to think about baseball answering truthfully earlier about what are we doing when we look at people to try to figure out, are they giving the whole story? Somebody can be telling you the truth about one thing and lying to the teeth about something else all in the same breath. We've all had that happen. You can tell me it's Wednesday and also tell me you're going to pay me on Friday. You can be right on Wednesday and be lying about paying me on Friday, right? So it's going to be really important as we go through this to very carefully scrutinize what was said, who was where, and what happened. And I want you to think about what these words that were said actually mean. Now, I want you to really think about, hear this evidence today as we move through it. Does it make sense? Call the sniff test. Pass the sniff test. Does that make sense? Do you believe that you presented with enough evidence to hold an individual who's presumed innocent until the government can meet that extremely high burden of beyond a reasonable doubt with their evidence? Now, there's going to be a story that's told today. And ladies and gentlemen, I believe the evidence will show us exactly what it is. Take the department back to my grandma. She had great sayings. They work. You had a really nice sweater. Just got a little string sticking out. Little thread. You don't tuck that in, right? Keep your arm down. Nobody notices. What happens when you start tugging on that thread? That sweater comes undone. And ladies and gentlemen, I believe if you follow me through this path and you walk with me, Mr. Fisher, down this path, as the evidence is presented to you, you're going to start feeling that tug. You're going to start feeling that gentle tug on the sweater. Well, at first, it sounds fairly plausible. But when you look at what you hear, when you think about credibility, who's saying what, it's very, very important to think about how that sweater's looking as that thread continues to get tugged on. When we start to see holes, ladies and gentlemen, I propose to you start seeing any holes. That's that right there. Your job's done for today. It's not your job to put the evidence forward. That's her job. It's just your job to put that evidence on the scale and say, does it show you this man committed the alleged act he's being accused of? One of the things that no one's really talked about yet today, it's very important as you go through today's process. Motive. Right? Very few of us, if we're sane people, do things for no reason, right? We don't just willy-nilly run out and do stuff. I mean, when we're teenagers, maybe. Young adults, maybe. But as we get older, we start to be a little more calculated, a little bit more deliberate in our actions. I think we would all agree on that. You carefully calculate things a little bit differently. The problem with a lot, ladies and gentlemen, is that it builds on top of itself. You start out with a, pardon my French, but a BS story. There's no fix. Can't cure it. You can kind of spin it and you can kind of jump to another spot, but you can't fix the original problem. And I firmly believe today when you watch and listen to what's being said, and again, what order things happened in, who was where, who was doing what, I feel confident. And I said I'm nervous because this is serious. I'm nervous because it means so much to me and my client, but I am confident. You're all more than capable. From the statements you made under oath today to the judge, the prosecutor, myself, you guys are for this task of looking at the evidence, sifting through it, and making a determination. Now, ladies and gentlemen, you're going to hear some evidence today that's, I don't know, it just kind of sucks. It's rough. Family was going through some tough times. You said before, Mr. Fisher, in his life, that it had a spot. You're going to hear testimony that supports that. Now, I believe you're going to hear testimony today, ladies and gentlemen, give you a completely alternate theory as to why somebody may have made an accusation that somebody would have verbally threatened them in a way that got the police involved. Now, you're going to hear more testimony today that says once an individual is arrested for a crime, a domestic violence crime, the very next step is the police officers remove them from their home. The marital. You're evicted. No judge, no 7-day notice to quit to get out of your house. Best case scenario, a couple days later, you're going to be given a police escort to walk back and grab about what you can carry.
This is where the case gets legally interesting. There's no dispute that no physical contact occurred, and that matters. Under Michigan law, the prosecution isn't required to prove a punch landed, only that the defendant intentionally created a reasonable fear of immediate harm. Raising a fist, having the ability to strike, and intending to intimidate, that's the legal framework the jury must apply. Everything you hear from this point forward will be measured against that standard, not emotion, not marriage problems, and not bad language alone.
So as you're thinking through, why would somebody ever? Why? Why would somebody say something that's untrue, be willing to come in and risk such a serious wrongdoing as lying? Why would they get to there? It doesn't mean you're a bad person. We'll talk before. Emotions happen. I'm not here standing today to tell you that after the evidence comes out today that the complainant, that Mrs. Fisher, is a bad human. I'm not here to say that she's a bad person. I'm just here to tell you that emotions got the better. She, I believe the evidence will show you, felt that she was in a situation where she was in a marriage that she was unhappy with. You're going to hear testimony that she didn't have enough money to move out to get a divorce attorney. And you're going to hear that she made that decision that night to involve her daughter in law enforcement to remove my client from his home. Because she felt that was just going to be the easiest way to get this. Ladies and gentlemen, I implore you, again, be open-minded, careful, and as the judge told you, if you have questions, don't forget to use Officer Crow. My client and I are more than happy to address everything. We look forward to this day, to be in court. He's not in fear of this. He's nervous, certainly, just like I am. But no one's in fear of this because this is the day, finally, the accusations, the baseless accusations that had nothing more than words behind them, are finally going to be brought in front of somebody who is neutral, who doesn't know the parties, who hasn't been involved with these folks before. You can look at it and make your own decision. I thank you all for letting me share this with you. I look forward to speaking to you again as this day goes on. Thank you.
Ms. Mandernack, are we ready for witness?
Yes, sir. People call Stevie. So I identified the people who just requested witness.
Okay. Is this lady a witness?
No, this is Mona. Our victim met.
Go ahead.
Thank you. Morning, Ms. Fisher.
Good morning.
Can you please restate your name for the record?
Stacey Fisher.
Okay. And just a couple of ground rules. When you're answering questions, I need you to verbalize your answers so the microphone can pick everything up. So no, no head shaking, yes, no, etc. I want you to keep your voice up, please, so that the microphones can record everything. I always feel like I'm shouting in court, so I want you to shout at me. The correct answer is the honest answer. There are no trick questions. If you don't know the answer to something, that's fine. Just tell us you don't know. If you don't understand a question or need me to repeat a question, because sometimes I talk fast, so you know, okay?
Yes.
Okay. Ms. Fisher, I'm going to take you back to October 22nd of 2024 at about 11 p.m. Where were you? Okay, I'm sorry. Could you just speak a little bit louder? Where are you bringing up?
I just got home from work.
Okay. And where is home?
6112 Swan Lake Drive.
And is that in the city of Romulus?
Yeah, I'm working this mission.
Okay. And where do you work?
Well, I have several jobs. I work at, DTW, airport. I work as a security officer there. I work also as a cosmetology instructor, in the city of Detroit. I also work at my church as a director of our children's ministry. And I also work at JCP Hair Salon. That's for it.
Okay. Where were you? You said you were coming home from work on the night of October 22nd, 2024. Where had you been working that night?
I had been working in Metro Airport.
Okay. And, do you recognize anyone in the courtroom today?
Yes,
Who do you recognize?
Carlos Fisher.
Can you please point to him and tell us something that he's wearing?
Carlos Fisher is wearing a white jacket.
Your Honor, yes, the record.
Noted.
Thank you. And, Ms. Fisher, how do you know Carlos Fisher?
Carlos Fisher is my husband.
Okay. Was he living with you on October 22nd, 2024?
Yes.
Okay. And can you describe the home at Swan Lake Drive to us?
It is a 3-bedroom, 2 bathrooms, colonial type home with an attached garage.
Okay.
And a large deck area on back.
Okay. Who was in the home that night?
I was in the home. Carlos was in the home. And our daughter was in the home.
Okay. What's your daughter's name?
Carlos Fisher.
Okay. And how old was she at the time of the incident?
19.
Okay. And what happened when you got?
Well, when I got home that night, I could not get in the garage. Only when I get home, I can usually use my garage opener to get in the garage. That particular night, well, before that, my garage opener came up missing. And so every time I get home, I have to call someone to open the garage for me. Or get out the car and press the keypad or something like that. That particular night, I was so tired. I just pulled it up in the garage, in the driveway. I sat there for a few minutes, and then I said, let me grab all my bags, get out the car. And as I was getting out of the car, Carlos was coming out of the house through the garage door.
Okay. Had you called him? You said that you had to call people to get in because your garage door opener you either didn't have it or it wasn't working. Did you call him to let you in that night?
No.
Okay.
This moment may be the most pivotal of the entire trial. The defense is zeroing in on what wasn't said, not what was. Despite a 9-minute 911 call, despite multiple opportunities to explain what happened, the alleged raised fist never comes up until later. So the jury now has to ask, is this a detail that was forgotten in fear, or one that evolved over time? And more importantly, how much weight should omissions carry when determining credibility beyond a reasonable doubt?
Did you have the garage door opener with you that night?
No. I had it missing for months.
Okay. And what happened when he came out of the house?
I had already grabbed all my bags, which was a lot of different heavy stuff. So I had already grabbed all my stuff, had stuff on my shoulder, hands, and I was walking up the driveway. He was coming out of the garage. We were walking towards one another.
Okay. Was he saying anything as he was walking towards you?
I don't know if he was saying anything as he was walking towards me, but when we got close, he said that he would move my car.
Okay.
I'm already in motion tired, ready to get in the house. And, he said, I'll move your car for you. I told him, don't even worry about it. Gotta work early tomorrow. I'm the first one out, so just let it sit. I'll just pull out tomorrow. And so at this point, I asked him, he's walking behind me back into the house. And he's asking me for a key. Give me keys, I'll move the car. Give me keys, I'll move the car. And I'm like, just don't worry about it. Don't worry about it. I'm out tomorrow. By the time we get in the house, he said, you heard me tell you to give me the keys. Why didn't you give me the keys? And I'm like, as I'm putting stuff down, I'm like, because I wear my keys on the lanyard around my neck. So I'm like, I'll just give him the keys to move the car. But before I could do that, now he's mad.
Okay, I'm sorry to interrupt, can you describe his demeanor at this point? His
Well,
body
at that point, he was, getting kind of loud and boisterous about me not giving him the keys and not moving fast enough. You heard me tell, this is what he said, you heard me tell you to give me the keys. Why didn't you give me the keys?
Okay, and what happened next?
I was standing at the table, where I usually, we have like our dinner table in front of our day area where the glass doors are. And so I was standing in the spot where I usually be, which is where my back is against the glass, towards the glass. And I was standing there giving me the hand and he was ranting stuff. He probably didn't even, I don't know. He was mad at this.
Okay, and what happened when you were standing near the dinner table?
Oh, he was cussing me out and stuff, and then he raised his fist up like he was going to hit me in my face, like he was going to come down at my face.
Okay.
And stop close to my face.
Okay, how far away was he from you when he raised his fist up?
Like,
Or where was he?
right here. He was on my left side. Like close. Like the fist was coming like this.
Okay, was he on the same side of the dinner table as you?
Yeah.
Okay. And I believe you previously, can you show us again about how far away he was from you?
Like where this thing is right here.
Okay, Your Honor, the complaining witness is touching the right side of the.
So-
I'd
Can we agree that's within 18 inches?
say within 8 inches. That is just,
Well, I guess depending on where we're going to measure, from her shoulder.
oh. I'll stick 18
Your
inches.
Honor, if we, objection, how do we ask her how many inches away do you believe his fist was?
Well, that's not the question. The question is the question was how far away was he? So was he closer than that juror?
Yes.
Was he half the distance between you and the juror?
He's like right here.
Okay. So if you would have done this, you could have hit him. If you would have stuck your elbow out, you could have hit him.
Oh yeah.
Okay. So within a foot or so.
Okay, thank you. And you said he raised his fist. Did he say anything when he raised his fist?
Yeah, he said, well, after he stopped himself, he said, honey, what you gonna do? Because you're a cop. And all you gonna do is call the police.
Okay. And when he raised his fist, did he move his fist towards you?
Yes.
Okay. How close did his fist get to you before he stopped?
Right there, 4 inches.
Okay. And what happened next?
I just did it. Because that's scary. That's scary. So I just stood there and he was starting, when he backed up, he started walking around, curling his faults, stupid and stuff like that, right? And so, trying to think exactly what he said, but he said,
Well, let me interrupt you. Did he threaten you in any other way that night?
Yes.
How did he threaten you?
After he stopped himself from eating, he started walking around the kitchen, calling me names and stuff like that. And then he walked closer over to where the garage door meets the house, where we go in and out from the house to the garage. He was standing there, and as he was walking over that way, he said something about he could be my ASS or something like that. And so, since he was away from me, I said, no, you won't. He's gonna beat you back. That's what I thought. And when I said that, he turned around, he had on a roll, gray roll. He turned around, he put his hand in the roll pocket, and like he had a gun. And he said, I'm gonna light your ass up. He started screaming, I'm gonna light your ass up. And he had his hand in the pocket like there was a gun in there. I was terrified at that point, because I don't know. This is not the first time he has threatened.
I'm gonna be stopping right there. Did you know whether or not he had a gun in the robe pocket?
I did not see a gun.
Okay. And what happened after he said he was gonna light you up?
My daughter was coming in,
Okay.
and his back was to her, and she said, when she opened the door, she said, who you gonna light up?
Okay.
And he turned to her and said, no, just move, let's go over these cars.
Okay, and what happened after that?
As soon as he walked out that garage door, I did exactly what he said I was going to do. I called around this police department, and I stayed on the phone with that dispatcher. The whole time he was in the garage, I was giving my account, telling him, I need a police officer to get here right away. The dispatcher stayed on the phone with me until they came.
Okay.
Well, even beyond that.
Okay. I'm gonna back up a little bit. When you first got home, was your daughter home?
Yes.
Okay. Do you know where she was in the house?
No, I was outside, but eventually came outside to move her car as well.
Okay. Was she in the house when Mr. Fisher raised his fist at you?
No,
Okay.
she had taken her car. Sometimes you take our car down the road to turn, maybe U-turn to come back around and pull in the garage. And so she had been out to do that. She was not there for any of the argument or anything like that. She came up when, as she came up, all she did was, I let your ass up.
Okay. And you stated that you called 911?
Yes.
Okay. Your Honor, I would ask to publish what I would admit is stipulation as People's Exhibit 1.
Your Honor, we have no objection other than unless you're gonna be at the timestamps that you discussed.
Didn't discuss timestamps for,
Well, that would be the,
because I don't think we discussed timestamps for this.
we didn't, so that would be my objection would be that, I have no issue with the video being played as stipulated to, with the exception of the standing objection we'd already raised during our motions to eliminate.
Judge, may I defend complimentary play approach?
Sure. While you two nail down the timestamp, I'm going to explain the stipulation to the jury that we discussed.
Yeah.
Well,
Yeah. So, if Mr. Hampkins was here, I'd let him explain it because he's been in so many jury trials. So you've watched TV shows. All right. So quite often when one side wants to submit some evidence, there's got to be a long foundation for the evidence, and the other side argues whether or not these two have stipulated that certain things are going to be submitted to you today. So, for example, what we've talked about, I'm not sure it's all going to come in, but what we've talked about is a 911 tape, or recording, I should say. That's how old I am. They used to put them on tape. A 911 recording. There's also some conversation about some body camera footage. Well, what the stipulation, which just means agreement, what they've agreed to is certain portions of that 911 recording or those body cameras are relevant for today and certain portions aren't. So you might hear some conversation and then there might be a pause where it's muted and then you might hear some conversation. You might see some video where certain parts of it are paused. That's because they've agreed, the attorneys have agreed that certain parts are relevant today and certain parts aren't. So I don't want you to get hung up on why aren't we hearing what we aren't hearing? Because they've agreed that it's not relevant for today. Understood? Thank you.
Apparently, good progress. Just please bear with us for.
Yeah. It's better than a foundation. I mean, this stipulation's quicker than laying the foundation. Oh, let's talk about this too. And it's already lunchtime. We don't break for lunch until you guys want to break for lunch, if you want to break for lunch. All right. So from the conversations I've had with the attorneys prior to getting started, I think this one's going to move fairly quickly now that we started the actual testimony and everything like that. So we'll just work until you say, hey, you know what, Judge, it's time for us to take a break. And then we can talk about how long a break you want. Fair enough? And that, I mean, that doesn't mean you guys all have to be in lockstep. If just one of you think, hey, Judge, I think we need a break, then I'll let you break as a group, decide what you want to do. And then I'm going to tell them that's what the jury's decided. All right.
The 911 call that we just heard, that was the first time you told law enforcement or, let me just back up. The 911 call we just heard, that was your first telling of the events of October 22nd, 2024, correct? You hadn't talked to police prior to that?
On that day?
Yeah, that was the first, that was your first time telling that story, correct? Then we just listened to that phone call. It was approximately 9 minutes long, correct? We just heard it? All of us here just heard the phone call, right?
Yes.
And you called 911 because you said you were scared and concerned, correct? Previously when you were testifying?
Yes.
Okay. And previously you testified that you were scared that Mr. Fisher was going to strike you because he pulled his hand back and he was going to hit you, right?
Yes.
Isn't it true that at no point during that 9-minute phone call did you make a single accusation against Mr. Fisher for raising his hand?
At that point,
Yes or no? Did you, isn't it true that during that 9-minute phone call, you were calling for help, at not one point did you ever accuse Mr. Fisher of raising his hand to you? Yes or no?
Yes.
Yes, you did say he raised his hand on that phone call we just listened to?
Not what I heard. I said, you said, isn't it true? And I said, yes.
So you called 911 and you reported that he was calling you nasty names, correct?
Yes.
You told them, he said you had no sex appeal, that you were a dumpy ass, correct?
Yes.
Okay, and you made mention that he may have been reaching into his bathrobe, correct?
Yes.
Very good. Okay, so you thought about mentioning that. You thought about mentioning the insults. You described to 911 where the cars were all parked, correct?
Yes.
But you failed to mention the very allegation that we're here on trial for today, correct? Which was that he raised his hand and acted like he was going to hit you. You never said that to 911 when you called for help, did you? Yes or no? Well, you just heard the video, or I'm sorry, the audio. It's true that you never said that during the call for help, correct?
According to what I heard, no.
Okay. Now, very early on that call, when you mentioned that he had threatened to light your ass up, 911 was concerned for you, weren't they?
Yes.
Right. They asked, could you get somewhere safe, didn't they?
Yes.
And you could have easily at that point gone somewhere safe, couldn't you? If you felt you were in danger. You could have left the house. Correct?
Yes.
Okay. But that's not what you responded to 911 with, is it?
I don't have to go to the doctor. I didn't have to go to the doctor.
No, in fact, what you said before you said that was, why should I have to go anywhere? Why don't you all come get him? Isn't that what you told 911 when they asked if you were safe?
Yes.
remember speaking with Romulus Police Department when they arrived?
Yes.
Let me back up. Did you make any false statements to the 911 operator?
No.
Now, the 911 operator told you to go get in your car to leave the house if you could, correct?
Yes.
But that's not what you did you?
Yeah, I got in my car.
Your car that was inside of your garage, correct?
Yes.
Okay, so you didn't drive to the police station.
No.
You didn't even try to leave the house.
No.
You just sat in your car in the garage after Mr. Fisher went upstairs and go to his bedroom and go back to bed.
Yes.
Okay. Now, if I told you it was Officer Green and Corporal Paisley were the officers from Romulus PD who you first met with, would you agree with that, or do you remember their names at all?
No.
But you did speak with two police officers when they first arrived, correct? Okay. Did you make any false statements to the officers? Did you leave out any important details that they would need to know in their investigation?
No.
Well, isn't it true, however, that you spoke to the officers right there where the garage door went up, right, standing in your driveway for probably, what, at least 5 or 6 minutes explaining to them what was going on, correct?
Okay.
Isn't it true that you told the officers that Mr. Fisher said, I'll light your ass up? You told them that, didn't you?
Yes.
And you told him that he was wearing a bathrobe and maybe he was digging for a gun in his bathrobe, right?
Yes.
Isn't it also true that once again, you failed to tell those officers anything at that point in time about Mr. Fisher allegedly cocking his handgun?
I'm not sure.
Mrs. Fisher, isn't it true that the one and only time you ever made that accusation was once you were filling out your written statement?
Your Honor, I'm sorry to interrupt. Can you approach?
Sure.
Don't know if there was a speaking objection or if that was just an approach. I don't.
No, I don't think there's any connection. No.
So since we kind of took a little side break there, the question was, let me back up in time. So you're standing in your garage, the garage door opens up, two police officers walk up to you, okay? You remember that?
Yes, I do.
Okay. And you remember telling the police officers what happened when there was two of them standing there?
Yes.
Okay. Is it true during that conversation, you explaining what had happened, you never made an allegation at that time about Mr. Fisher raising his hand to you?
I told you, I'm not sure whether I told you about that part or not. My conversation was about the life-threatening event that had just happened to me. If he had hit me, I probably would have died. But if he had shot me, I would have died.
Well, I'm glad you brought that up, because the officers, in fact, asked you, did you ever see a gun? And you said, no, I never saw a gun, correct?
I did.
911 asked you, did you ever see a gun? You said, no, I didn't, correct?
That's right.
Mr. Fisher was wearing a gray bathrobe loosely tied at the front, correct?
Yes.
Okay. So, did you believe that Mr. Fisher was carrying a handgun in his bathroom?
Yes.
You never said that to police, though, did you?
Yes, I did.
You said he had a gun on him?
Yes.
Your testimony here in court today, under oath, is you told police officers that he had a gun?
Yes.
Are you sure you didn't have another conversation with police saying, I don't even know if he has guns? Isn't it in fact true that's what you told police?
No, because Mr. Fisher is obsessed with guns lately.
That wasn't the question, man.
I would never have said, I don't know if he has weapons. He has well.
Ma'am, I'm going to stop. Ma'am, I'm going to stop you. So do you remember speaking with police, correct? And you're aware that the police were wearing body worn camera that night, correct?
Okay.
Right. Isn't it true? Bear with me. That also, I'm going to ask one more time. Give the video. Isn't it true that when you were asked, does he have a gun? Your answer was, I don't know.
I could not imagine the same round.
So does your answer is, I can't imagine saying it, or you're telling, I just need to clarify.
You know, I would never have said, I don't know. I have had to take many of the weapons to the Romulus Police
I'm going to
Department.
stop you there, man. That wasn't the question, and that's not what we're talking about. We're talking about October 22nd, 2024 right now, okay?
Mhm.
And about what you said to police, okay?
Yes,
Then we just listened to the 911 call. Let's just back up to there. We just listened to the 911 audio. Everyone here did, correct?
so,
We can play it again if we like. Isn't it true that at about 3 minutes into that audio, or a minute and a half into that audio, the 911 operator actually asked you, "Do you see a gun?" You said, "No." You said that,
I
correct?
said no.
Did it say no? Okay. And Mrs. Fisher, you know that 911 instructed you to get out of the house or to go to safety, and you said, "No, I don't need to leave. He should leave," correct? We covered that.
Yes,
Okay. Now, we do hear Mr. Fisher come back into the house on that audio we just listened to, didn't he? Isn't it true at no point during that audio did he mention anything other than the vehicles that you guys were fighting about? At any point in that audio, did you hear him threaten?
no, I just heard him say I'm a nasty housekeeper and, all these insults, I heard that.
He was saying a lot of mean things to you that would hurt your feelings, no doubt, correct?
Yes.
No one likes to be called names. At least I don't. Do you like being called names by your husband? But not. I heard it wasn't a nice thing to say. But there was no threat, was there?
That's probably because my daughter was back in the house.
Okay, we'll talk about where your daughter was and wasn't in a minute. But there was no threat.
No.
Okay. In fact, Mr. Fisher, after the discussion about where the cars were parked, he went back upstairs, didn't he?
Yes.
Can you describe what Mr. Fisher's health was like at that point in time?
Here we go.
I'm sorry, what do you mean, here we go?
That's his game.
Ma'am, do you think what was his health condition at that time? Where did he have to be that next morning?
Yeah, to be in the dialysis.
Do you think kidney dialysis is a game? Why would you say that his illness is a game?
No, his illness is not a game. It's just the way he does it. Like, he'll, in front of certain crowds, he'll pull his cane out or some crutches. As soon as that crowd is no longer present, that cane is in the garage somewhere. I mean, it's a game
Okay.
for him.
Okay. So do you think it's a game for him to go to dialysis at 4:30 that morning?
You know?
Was Mr. Fisher, at the time this happened, in frail physical health?
No.
No. He had no problem walking up and down stairs?
Your Honor, I would ask that we lay a foundation that complaining witness has personal knowledge, and I just want to be careful that we're not getting into complaining witness testifying to a medical diagnosis. She's not a medical doctor.
Fair enough. Your Honor, there was no request for any medical diagnosis of this. They're a married couple. She's acknowledged that she knows he has dialysis. She stated she thinks that he uses it as a game. I think that's where we landed. Go ahead. Mrs. Fisher, you made statements to law enforcement that you and Mr. Fisher were no longer a couple.
Well, and
Did you?
we still live in the same home, but in many ways we're very different.
That's not what you said to police, though, did you? You told them that you guys the relationship was done, correct? And you were speaking to the police officers that night. You told them, in fact, you guys sleep in separate bedrooms.
We sleep in separate bedrooms.
Didn't you tell him, in fact, that the officers, without being provoked, you threw out there that you thought 2.5 years ago Mr. Fisher was out cheating around with other women, didn't you?
Yes, he was.
So you told police about Mr. Fisher's alleged infidelities and about the name calling, correct?
About the threat of my life.
So that's what I'm asking about. You mentioned the name calling.
Okay, let's calm down, because I only want one person speaking at a time.
What was in it?
This is not the first time that he's read to shoot.
Okay, you've said that a couple of times. That's not what we're talking about.
Well, at some point, I have to believe if he's telling me that he's going to shoot me, I mean,
Do you remember actually the officers asking you that? Actually, Officer Green asked you, do you believe he has the ability to shoot you? And you couldn't even say yes. In fact, you answered, well, I watch the news and it happens all the time. But you didn't tell him that you personally thought that Mr. Fisher was going to kill him, did you?
Well,
Yes or no?
I was answering that question from my heart. But my mind, yes, it is true.
That's not what you told officers. That might be your answer today, but that's not what you told police when they asked you. In fact, Mrs. Fisher, common sense says if you thought he was going to shoot you, you wouldn't have stayed in the house, would you?
Yes.
So if you thought that your life was in danger, that someone was going to shoot you, you would have just stayed right there?
Well, I did not have anywhere else to go.
That's not my question, ma'am. Ma'am, there's plenty of places to go besides being shot. Isn't it true that you did not make any attempt to leave a house and you just told us that you were in fear for your life?
I did go in the garage and was not going off for no reason.
That's not my question. I said you made no attempt to leave.
Exactly.
Okay.
Right.
Now, we heard a lot of sound and audio on that 911 call. And do you remember telling 911 he's coming back inside, referencing Mr. Fisher?
Yes.
Okay. And isn't it true, unprovoked, you just yelled out, "Don't you ever shoot me again." You remember hearing yourself yell that out?
Yes.
Isn't it true that for about the next 30 seconds, we don't hear you or Mr. Fisher on that audio at all, do we?
He was on his way up the stairs.
We don't hear you or him. We've heard background noise the whole time. Did you mute your phone?
No.
Okay. It's just coincidentally after you yell, "Don't ever threaten to shoot me again," he doesn't respond and just walked upstairs.
Yes.
And you didn't say another word?
No.
Okay.
I'm not going to escalate the situation.
No. But isn't it true that you admitted to officers that you in fact did escalate the situation that night?
No.
No? You didn't tell officers that when you guys were having an argument, and I quote, "You shut up or I'm going to knock your head off." You don't remember telling police officers that you said that to Mr. Fisher in the kitchen?
Oh, yeah. When I said, "Oh, he back." Yeah.
No, ma'am. Isn't it true? Oh, hit him back. Were you hit?
He said that he was going to whoop my head or something like that. And I told him, "No, you won't, because I hit you back."
But you never told law enforcement that he was going to whip your head, did you?
I'm sure I did.
You're sure you did.
Yeah.
And we'll get into what the officers and what was said and wasn't, but your testimony.
I'm sorry to interrupt, Your Honor. I just want to clarify, was that, whoop your ass or shoot your ass? Or light your ass up?
Light your ass up that was also said.
I just wanted to clarify that that's not.
And Mrs. Fisher, when he said light your ass up, you previously said you thought he meant he was going to shoot you, correct?
He did mean do something.
Okay. So light your ass up didn't mean anything about reaching his hand back to hit you. It's about shooting you. Is what
Those are the two separate things.
right. That's what we're trying to clear up. Okay. The handwritten victim statement. That's okay. You left out in your victim statement the fact that you had also made verbal threats to Mr. Fisher, didn't you?
Let me see it.
Well, you're going to let the record reflect on approach to witness your own victim impact statement. I don't want to ever refreshed on cross, but we're going to give it a shot.
I'm sorry, Judge, is it the victim impact statement or the written statement she gave you, please?
It is titled Domestic Violence Incident Victim Statement. I can give opposing counsel a copy because I thought we might be getting to this.
Okay, thank you. I just wanted to make sure the victim impact statement, but I want to make sure.
Your Honor, would you like a copy as we go?
Sure.
The record reflect, handing a copy of the victim statement.
I'm sorry, are we marking this for purposes of the record? Even if it's just being used for.
It hasn't been laid yet. We'll see. Don't read from this document yet, Mrs. Fisher. Just tell me what this is.
Violence incident, particular statement.
Okay. This is your statement, correct? Has it been altered or changed in any way? Do you have any reason to believe the police changed your statement?
You asked a question, I don't know.
I'm asking a follow-up question. Do you think the police changed your statement?
False for speculation.
Withdrawn. I'm going to ask you again. Go ahead and read through the statement. Is this your statement?
Yes.
Isn't it true at the end of your statement, you said, right, well, I called the police to report both threats of violence against me, end quote. Those are your words, correct? Right on the statement. Is that what you said? Very last sentence.
Yes.
Isn't it true? You called 911. You, in fact, did not report any alleged cocking back of the fist, as we covered earlier.
Yes.
But Mrs. Fisher, your daughter was there. She made a statement to police as well, correct?
Yes.
Okay. You weren't standing next to her when she made her statement,
No, I was not.
so you wouldn't have been impacted what she was going to say to police. Okay. Do you think your daughter had any reason to lie?
No.
Okay. And you stated that your daughter was inside the kitchen area, and that's how she was able to hear. I think, as you stated, I'll light your ass up. Correct? That's what you previously testified to, that your daughter. What'd you say? What'd your daughter hear?
She's coming in from the garage.
Okay. And you said that she didn't hear anything other than the statement, "I'll light your ass up." That was your.
Objection, Your Honor, that calls for speculation.
That was the previous testimony, Your Honor, on direct.
Yeah, I don't think it caused speculation to, the way I understood, you were asking her what she said.
Correct.
So maybe restate the question.
You testified earlier today, and you stated that your daughter heard Mr. Fisher say, "I'll light your ass up." You said that earlier, correct?
Yes.
You can remember what you just testified to a little bit ago, right? I'm not trying to jam you up. Remember what we talked about?
I don't know if she heard. The only way I know she heard that is because I heard her say, "You will like Uber."
But you previously testified that she hadn't heard any of the other argument, correct? Today you testified.
Today I said that.
Yes, you said that the only thing that she walked in and all she had heard was the tail end of the argument.
That's all I think she heard.
Okay.
That's all she heard. So
So that's you. So I just want to make sure you're changing a little bit now. You're saying that's what you think she heard.
I'm not changing anything.
Good.
I'm not having.
You did previously testify that the only thing she heard when she walked in.
Okay, the only thing I think she heard was that. I'm not in her ears. I don't know what all she heard.
Okay.
And that's fair enough.
And where was she at when, in your mind, when this was said? Where do you believe your daughter was standing when she heard?
I don't know.
You have no idea where she was standing. Well, I'll put these back together, Your Honor, in case we need it again. Well, go ahead and move to admit the victim's statement as will be defense exhibit, I guess that's one. Yes, Your Honor.
No objection, it's 2 pages. Correct.
It is.
That'll be admitted. What do we call it? Defense one?
So I want to jump back to that 911 call that we all listened to. The 911 call, very beginning of the phone call, the officer or the dispatcher was concerned about your well-being, and he stated to you, did he actually hurt you? Do you remember hearing that?
I don't remember one.
Okay.
You talking about
Right when you called 911 and you stated, my husband, first you started with my husband and I were arguing.
Yes.
And then you went into the allegations that he said, "I'll light your ass up and reach for a gun." Okay. We've established that there was no mention of raising a hand during that 9-minute phone call. No allegations about the punching or alleged acting as he was going to punch. You responded to 911 when they said, "Did he actually hurt you?" with a question back. Do you remember that saying, "Did he hit me?" That was your question. Back to the operator, right?
Yeah, if you want me to answer it, play it again, because I can't remember that.
You want to cue it up and pull it in? While I'm doing that, Mrs. Fisher, isn't it true that at that next question from the 911 operator, he stated, the operator, "Did he hit you or do anything to you?" You responded no. Do you remember that? No problem. Well, bear with me, Nice. Heather, do I need to hit anything to get audio up?
I don't think so. I think audio will go. What do you think, Joe?
Well, Your Honor, when you said that nobody was to be less stressed with digital computer things than him, I almost jumped in and said,
Do you want to use my computer, Josh?
I've got it right here. Let the record reflect.
Okay, what's going on? Did he actually hurt you? Yeah, okay, or did anything?
Okay, so we just heard it. The operator first asked you, did he hit you?
No, nothing.
Okay.
That's already said.
Then the operator asked you, did he do anything to you? And Robert said, no, correct? So we just heard it. Okay. Just a few more questions.
At its core, this case is a legal tightrope walk between emotional reality and evidentiary precision. The prosecution argues that fear itself was the weapon. The defense argues that fear must be proven, not assumed, and that inconsistencies matter when someone's freedom is on the line. Now it's up to the jury to decide whether the evidence, taken as a whole, proves assault beyond a reasonable doubt. If you found this case as shocking and complex as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
Now, do you remember when you were speaking with the two officers, at one point, one of the officers pulled you with him to go do the statement, and the other officer went inside the house? You remember that, right? Okay. So you were with Corporal Paisley when you, let me just back up, I'm not sure who was the officer. Do you remember the officer that was helping you fill out the statement that we just admitted into evidence? Do you remember speaking with him?
I remember speaking with him on the third, I don't know what his name was.
Do you remember stating that you guys have been married for 20 years?
Yes.
You were stating, he's just real mad at me because 2.5 years ago I caught him in a whole bunch of cheating mess. He's just mad that I'm not accepting that. You remember stating that?
Yes.
Do you remember then continuing on with that, saying, we don't even talk to each other. I don't know. We aren't back together. I just can't afford to move.
Yes.
You told him again, if you could afford to move, you would have left. Correct? Prior to this night.
Possibly.
All right. No further questions for Ms. Lewis.
Ms. Mandernack, redirect.
Your Honor, I request permission to publish Defendant Exhibit 2.
That was a stipulation too.
This was already submitted by stipulation.
911 call or what is it?
Oh, no, this is Defense Exhibit 1. This is a copy of the complaining witness written statement.
So I believe the people admitted the 911, that would be Exhibit A, and this would be Defense Exhibit 1.
Well, we're doing 1 and 2. So you want to publish his exhibit?
Yes.
Yeah, go ahead.
You plugged in? So do you? Yes, please. You should be able to see this on the little screen in front of you as well. This is a copy of what's been admitted as Defense Exhibit 1. What is this?
Violence incident with rape.
And I can hear what the word. Your Honor, may I approach?
Yeah.
Ms. Fisher, I'm handing you what's, you've already got a copy of it, but I'm handing you another copy of what's been admitted as Defense Exhibit. Defense Exhibit 1. What is it I just handed you?
Violence incident with rape.
Okay, and who wrote out the statement?
I did.
Okay, is that your handwriting? Okay, and when did you give this statement?
Pardon?
When did you give this statement?
Night of this.
Okay. And in the statement, do you state that Mr. Fisher told you that he was going to light your ass up?
Yes.
Okay, then you indicate in the statement that he also reached into his pocket like he had a gun.
Yes.
And you also state in the statement that he also raised his fist close to my face as if he was going to hit me.
Yes.
But it stopped and said you were a coward and you were just going to call the police.
Yes.
Okay. Thank you. Your Honor, will you unplug it? And Ms. May I approach?
Yeah.
May I continue permission to approach?
Yeah, go ahead. Stop.
I'm gonna
She got it. So.
take that one from you too. Thank you. And Ms. Fisher, you spoke with police officers when did you speak with police officers when they came to the scene? And were you truthful when you spoke with the police?
Yes. Yes.
Okay, so we needs to be a foundation with some multiple statements in.
So this is,
Yeah, I'm gonna.
Your Honor,
Go ahead.
I am going to admit, or I'm seeking to admit as People's Exhibit 2, via stipulation of a portion of the body, the audio portion of the body on camera, where complaining witness is speaking with, Paisley, who has responded to the scene. I intend to start it at 14:09.
And
And I intend to stop it at 22:39.
Agreed?
Your Honor, without being able to, I'll,
If defense counsel would like to view it, I'd rather.
I've made my objections as to what's inadmissible on this. I think we know what the third rail is not to touch. If the ADA is stating that no, inadmissible evidence is gonna come through on this, I don't need to delay the process.
That's fine.
Clarifications for referencing.
Just fine.
So it's basic objection form. So as to not confuse and needlessly delay this, what I would ask is to be clarified when in the interview, when in the evening this interview occurred. Because we've established there's been a 911 call.